First matter to come before the court this morning is State versus Reginald Johnson. Mr. Follett, it appears as if you have frightened the prosecutor away. They waived their argument, and so you'll have 15 minutes to do as you wish. If you'll give me just a moment. This case was scheduled for oral argument, I think, April 7th, if I'm not mistaken. And that's where my notes are. All right. We've read the briefs and we're ready to move on.
Thank you, Your Honor. Good morning. If it may please the court, my name is Jeremy Villette, representing the appellant in this matter, Reginald Johnson. Your Honor, this is a case of what happens when none of the, legal players in a case, and by that I mean the court, the state, or in some aspect, in this case, the defense attorney himself, actually fulfill their constitutional obligations of fairness and due diligence. And by that what I mean is this, is that in three respects, the three substantive respects, the prosecutor had a particular duty to ensure that the presentation of witnesses was fair and was not improper. And in this case, the key witness for them, the witness that actually said the defendant, Reginald Johnson, did this act intentionally, that he was the person who stabbed, that he was the person who started this fight, etc. That witness only could identify Reginald Johnson after having an out-of-court hearing or meeting with the prosecutor and the detective who brought her to court, after her initial testimony.
This is when she had another look and a closer look at the defendant, correct?
Well,
I mean, I'm trying to recollect all this. There's many facts in this case, but isn't that the key issue? What happened after she recognized that she had not testified, that she could recognize him? Excuse me.
Well, that was the statement from the prosecutor.
Right.
And there was nothing beyond that. The defense attorney objected to her being recalled, objected to the circumstances of her recall, because she had so clearly, so many times in her initial testimony been asked, can you identify this person? And he's sitting in court. This wasn't like, oh, can you identify the person? No. It was repeated over and over, both in direct and in cross-examination, over and over. She goes out of court, and there's nothing even in the record to show on her way out of court there was some motion or conversation. They get out of the courtroom, and what we know at this point is it's the detective who actually brought her to court because she had an active warrant, with the prosecutor. Then they come back in, we want to recall her. And the defense attorney objects. And the prosecutor says, well, Your Honor, she informed us that she can now identify the defendant. But my point with this is that, at the very least at that point, the trial court, under these circumstances, had an obligation after this objection about these circumstances, because the standard is, in fact, whether at that point we've got an improper influence going on. At the very least, the court should have inquired, either in camera or out of the presence of the jury, about just what it is that happened. The trial court didn't even go that route. The trial court simply overruled the objection and had the witness get back up on the stand.
As I read the brief, it occurred to me, and certainly the state's brief pointed this out too, that the action of the court is constrained or confined by the objection that's made. And so I'm wondering, because it was not in your brief, what was the specific objection to the witness being recalled? Was it based on the reliability of the witness? Was it based on suspicious circumstances? What was it that was placed before the judge at the time that that decision was made?
I cannot remember the exact words because I believe they had a sidebar and they came back later to show that it was preserved. So unfortunately, the exact conversation we don't have.
So we can see
But
the transcript.
in terms of the sidebar, was not transcribed. That's the norm for this particular court.
It was not transcribed, but
Right.
there is a record of it.
Later on, they came back onto the record to say that the defense attorney had properly objected, is my recollection.
Improperly or properly?
Had properly objected to that. But the circumstances
But we
were,
still don't know what the basis of the objection was.
I can't remember the exact wording, Your Honor, and I apologize for that, but my recollection was it was in fact the suspicious circumstances of the recall. The defense attorney did give explanation of that when they came back.
Suspicious circumstances is not very precise.
Well, unfortunately, no, it's not.
Is it that there was the private conversation outside of the court?
Correct. There's the private conversation outside of the court, the witness's testimony, all of a sudden changes 180 degrees. And at that point, you know.
When does it come out, if it does, on the record, that the witness had some difficulties seeing or visualizing the defendant, and it was only when she went by closer that she then recognized him?
There was never an indication that she had difficulty seeing the defendant in her initial testimony. It was only the prosecutor came in saying, afterward, the prosecutor said, when leaving the courtroom, she realized she could identify the defendant. Prior to that, there was never any, and even in his statement, there was never any indication that she had difficulty seeing the defendant, that he was blocked, or she had vision problems or anything of that nature. And she had been asked multiple, gosh, I think it was at least 6, 7, maybe 8 times whether she could identify the person, the assailant, and she said no. And that would actually make sense because she admitted to being intoxicated. I mean, she's brought in by a detective while she has an active warrant, and then there's this out-of-court conversation. And part of my point of this is at that point, Your Honor, once that objection is made, and unfortunately the record doesn't reflect this, this court's rules are also generally, you don't argue out your objections. You make your objection, the court rules. Sometimes you have the sidebar stuff, they'll come back and the court will say, you know, you preserved your objection, etc. And in this case, I believe it was Attorney Wallace, when it was on the record, stated it was because of the circumstances of they took her out, she couldn't ID him before, they get outside the courtroom, and now all of a sudden she can ID. And that was the basis of his objection. And my point is,
when she is cross-examined, when she comes back and is recalled and cross-examined, did defense counsel at that time probe into the issues that you're raising? You know, the fact that she had a warrant, the fact that she was escorted out of the courtroom by the detective and/or the prosecutor, and then immediately came back in.
The issue of the warrant came up in her initial cross-examination.
Okay.
I do recall that. And unfortunately, when they came back into court, the defense attorney did not in depth go after her about what this conversation was. Unfortunately, I mean, what I was able to piece together from the transcript is I think that because the court was allowing her testimony, he was, you know, they argued this out at sidebar, and he wasn't really allowed to get into that at that point. And that's part of why I say, at the very least, the court should have inquired of the witness, hey, and that would, in and of itself, given a guarantee of fairness, if we actually had a record. The witness says this is what occurred to the judge, whether it's an in-camera transcript or just an inquiry away from the jury.
Is there anything in the transcript that indicate a passage of time? Like if she passed on the way out and said something and just turned right around and came back in, there's no indication of an hour? Was it 15 minutes? Was
No.
it 5 minutes?
They left the courtroom, they were out of the courtroom for a few minutes is what's in the record, and then they came back in. So it wasn't an hour or anything like that, but they had in fact completely left the courtroom. And that's where the conversation occurred.
Were other witnesses called in the interim? Do we know?
No. So with that, and that actually in part where I said the court should have inquired, that leads as well into another error that occurred in this case, and that is the court did not give a self-defense instruction. And in this case, it's very clear that the court should have done so. Well, the court said, well, the defendant didn't testify, and therefore, I'm not going to. But everything that you need to actually at least present some evidence of to justify the instruction was actually presented through the state's witnesses. The state's witnesses, who actually owned and ran this bar, the two people who were not intoxicated and not part of this fight, stated that the defendant was not at fault, that in fact, I believe it was the witness who changed her testimony, was the one who actually started the fight, sucker punched Mr. Johnson, and was actually attempting grabbing beer bottles, not beer bottles, liquor bottles to further attack him with.
Excuse me for interrupting. You said that the court did not give the self-defense instruction. The court gave both parties copies of the proposed jury instructions. Am I correct? And that's
Correct.
What did the defendant do, if anything, after receiving those instructions?
They requested, Attorney Wallace requested the self-defense instruction.
And that's in the record?
And that's in the record.
And the court said no, or no because?
Correct.
What are we going to find?
The court said no. Part of the court's reasoning was that Mr. Johnson had not testified. And so in the court's mind, there was no evidence of a belief of imminent danger.
So, because there was no clear evidence of subjective fear.
Right.
Okay.
But, the witnesses testified that he was not at fault. Those same two witnesses testified that he was clearly only protecting himself. They testified about his change in demeanor, how he was calm, not causing problems, and only reacted when he was attacked. They even testified that to the extent somebody was stabbed, it was not an intentional act on his part and that he was attempting to hurt somebody. It was just something that occurred while he was trying to defend himself from this attack, which included people, a woman coming after him with liquor bottles. And that was part of the arguments was that at this point, there's enough evidence to show clearly that he was in fear and he was only solely protecting himself. And, a jury might come back and say, you know what, we don't find by a preponderance of the evidence that it was self-defense. But at the point of requesting the jury instruction, the state's own witnesses presented sufficient evidence to justify the instruction being before the jury. And the trial court saying, well, just because the defendant didn't testify, when there's such clear evidence from independent witnesses that he in fact was in fear for his own safety, that he was only acting in self-defense. I mean, they described him being sucker punched. They described, the viciousness of the attack upon him. And in that regard, there was sufficient evidence to at least justify the jury instruction. And the court just not doing it under these circumstances was an error.
On page 15, the bottom of page 15 of the brief, you set forth the requirements of the defense. And you say as to the second element of the defense, the jury must consider all circumstances to see whether the defendant had an objective reasonable belief of imminent danger and if he possessed a subjective honest belief that he was in danger of imminent harm. And so your argument to the court today is that notwithstanding there are two prongs to this, that the second prong of subjective honest belief can be established by witnesses other than the defendant.
Yes, I think there would be circumstances where it's so clear whether it's the defendant's expression, his own words, I think as well as his own conduct, that would show that this individual had a personal belief that he was in fact in imminent danger. And to simply say, well, you must put, I understand, if this was a different circumstances, there is some question about whether the defendant was the aggressor in terms of the independent witnesses or whether he was acting in some way, to harm another person. I wouldn't be able to make that argument, but these individuals who were actually having conversation with the defendant or watching him, described his behavior before, during, after, they described his conduct, his actions. It was very clear that his own actions, expressions, etc., in the course of this event showed that he had that subjective belief. And it was conveyed to other individuals that clearly.
And we'll find that detail in the transcript?
I believe so.
Have you pointed to that testimony in the brief?
I did. The testimony of both Wells and Roper I cited throughout. And those were the two bar owner managers who testified in this regard.
You have less than a minute, about 45 seconds.
Okay. My last point, Your Honor, is, and I'll make this very quick, with defense counsel. Defense counsel also failed Mr. Johnson. In this case, he didn't subpoena what actually would have been a key witness for the defendant. The trial court itself stated the importance of this witness, Officer Urdiales. The trial court's exact words were, yeah, you can make hay with this. Because Officer Urdiales would have established the defendant showed injuries consistent with being sucker punched. He didn't have blood on him like he was attacking other people. He didn't match the description of the assailant that had gone out over police radio, and he in fact didn't have any weapons. And it would have backed up Mr. Johnson's claims at trial that he in fact was not the aggressor, that he was only defending himself, and that he should not have been found guilty.
So are you asking us to, I understand the facts of this case, but it seems as if you're asking us to decide as a matter of law that if a defense counsel goes into a trial, the prosecutor has the name of a witness, a police officer, that the defense counsel chooses not to subpoena that officer, believing that the officer is going to show up, that as a matter of law, that is conduct that is below the standard of legal care. Because it'll go beyond the facts of this case. I'm just talking about generally.
I don't think generally that would necessarily be the case. And the reason being is, and it does deal with this case, because we have a record from both the trial attorney himself, where he gave a proffer, and we have the comments of the trial court acknowledging the importance of this witness. And I think that when you have a key witness, even if you presume that witness is under subpoena by the state, if you take no action whatsoever to secure that witness's presence yourself, and thereby prejudice your client in a fundamental way, then that is ineffective assistance of counsel. And I don't think that's a harm that can be overcome.
Thank you. And you have run out of time. Thank you for your presentation. The court will take the matter under advisement. We will issue an opinion which will be sent to both sides, and of course you check the Supreme Court website as we post our decisions. Thank you. Have a nice day.
Thank you, Your Honors.